All right. Okay. All right. Good morning, everyone. We're going to be getting started. I'm Reshma Shamsudar. I'm Deputy Director of Programs at the National Immigration Law Center. And today we're going to be talking about a lot of important developments that we've had both over the course of the past couple of weeks, but most importantly today, we have a lot going on both with the Supreme Court as well as both policy proposals and others that will be moving forward this week. So we have with us today a whole wide range of NOC staff to discuss these proposals, these developments, and we will be taking questions both throughout the course of the presentations as well as at the end. So to get us started, we're going to have Nico Espirito, who's going to be talking about key immigrant rights cases going to the Supreme Court. As you present.
Thank you very much. This is Nico Espirito, staff attorney with the National Immigration Law Center. I'm here today to talk about two cases which are currently before the Supreme Court. The first, Arizona Dream Act Coalition v. Brewer, and the second, International Refugee Assistance Project versus Trump. I'm going to start out by talking about the ADAC v. Brewer case. So this case was brought in 2012 by the Arizona Dream Act Coalition and others who we represent in this litigation, along with the ACLU and the Mexican American Legal Defense and Educational Fund. Here we are challenging Arizona's policy of denying driver's licenses to DACA recipients. Arizona state law let all individuals who had authorized presence under federal law receive driver's license, but nonetheless, after the announcement of the DACA program, instituted a policy that would have denied driver's licenses to these individuals. Over the subsequent years, we've been litigating this case, and we've been able to get a permanent injunction against this policy that was issued by an Arizona district court and then later upheld by the Ninth Circuit Court of Appeals. Earlier this year, the state of Arizona appealed this decision to the United States Supreme Court. And we've been in the process, and we've completed our briefing on the petition for certiorari filed by the state of Arizona. What that means is this petition for cert is Arizona's request that the United States Supreme Court hear this case. This morning, the Supreme Court asked for one other group's opinion as to whether it should hear this case, and that is the Solicitor General's Office of the Department of Justice. That is the federal government's branch who normally weighs in and argues cases before the United States Supreme Court. So what does this mean? So oftentimes when the Supreme Court is asked to hear a case that implicates key issues of federal law, that implicates key issues of the separation between federal and state power, or implicates key questions of constitutional law as to what the scope of the federal government's power is, the Solicitor General is asked to weigh in as to what the federal government's opinion in these cases are. And so it is kind of regular course of business for such a request to come from the Supreme Court to hear what the federal government's opinion about this matter is, even though the federal government is not actually one of the litigants in this case. Now, really, what the question we have here is what is the federal government going to say? And that this is a key concern for DACA recipients, the immigrants' rights community, immigration community, because what the federal government has to say through the Solicitor General briefing is going to be viewed, taken very seriously by the Supreme Court. It's going to look at these opinions. It's going to look at the opinion of the Solicitor General as guidance for how the federal government views this split, and it can be very influential to the court whether it decides to ultimately take this case. I want to reiterate, once again, the Supreme Court has not yet decided whether to take this case, but has only asked for the federal government's opinion about this case at this point. And so this is really a key moment for us to determine, to hopefully get the federal government to do what it said it's going to do, which is continue the DACA program and to support the legality and continuation of granting deferred action to individuals who would be eligible under DACA. So, just as final matter of what are the legal issues before the court. So currently, Arizona's policy has been deemed to be preempted because only the federal government has the ability to define who has authorized presence and who doesn't. And the Ninth Circuit Court of Appeals noted that Arizona's policy diverged from the federal government's determination about who was authorized and who wasn't, and therefore determined that this policy was unconstitutional. Also potentially before this court is whether or not discrimination, like the state of Arizona was doing against DACA recipients, is unconstitutional. And finally, because Arizona is challenging the legality of DACA, the future of DACA could potentially be at stake, which is why it's critically important that the federal government knows that it needs to continue to support the DACA program as it's assured immigrant communities that it would. That's just our quick overview of the ADAC v. Brewer case. We don't quite know yet when the Solicitor General will be filing this brief, but we'll be updating the field to let folks know as we get more information about the timing on the briefing and any subsequent developments in this case.
So just quickly before we move on to an update on where we are with the Muslim ban case, I think we do want to say briefly on behalf of all of us here at NOC as well as our partners that this is really a critical moment for those of us within the immigrant rights movement to be speaking up loudly to ensure that President Trump and his administration live up to their promise to protect DACA. So we'll be in touch in the days and weeks ahead in terms of next steps, but this is a critical moment for engagement, and we're looking forward to continuing this conversation about how we act to hold the Trump administration accountable. So there will be time for questions, but before we do that, I'm just going to turn it back over to Nico to talk about the Muslim ban case and what we heard from the Supreme Court this morning.
Thank you, Reshma. As folks may have heard, the Supreme Court issued both granted cert, that is accepted for review our case in IRAP v. Trump, as well as Hawaii's challenge to the Muslim ban case as well, Hawaii v. Trump. What it also did was it modified the injunction that is currently blocking parts of the executive orders that were challenged in these two cases. And so I'm going to go into a little more detail, both to explain a little bit of background about these cases, but also what happened today. So as folks may know, IRAP v. Trump is a case brought by HIAS, a refugee assistance organization, as well as the International Refugee Assistance Project. These, as well as individual plaintiffs affected by the Muslim ban. These individuals were represented, or I should say are represented by NILC, as well as the ACLU Immigrants' Rights Project and the ACLU of Maryland. Prior to this, the Fourth Circuit Court of Appeals had upheld the injunction against part of the executive order that banned individuals from 6 predominantly Muslim countries from entering the United States. There, the Fourth Circuit said that the executive order violated the U.S. Constitution and, quote, drips with religious intolerance, animus, and discrimination. The Trump administration asked the United States Supreme Court to both hear this case, but also, in the meantime, until it could hear that case, to lift the injunction that the district court had put in place and that the Fourth Circuit had upheld. Similarly, in the related case, Y v. Trump, the Ninth Circuit had not only blocked the portions blocked that related to the 6 predominantly Muslim countries, but also Section 6 of Trump's executive order, which lowered the number of refugees that could be admitted into the country, as well as temporarily halted refugee admissions. Once again, the Supreme Court asked the Supreme Court to lift the portions of those injunctions until the Supreme Court could ultimately hear the merits of those cases. So today at the Supreme Court granted cert, that is, decided that it would hear arguments in both of those cases, and we expect that those cases will be argued in early October. It granted a stay, that is, it lifted part of the injunction, but only to foreign nationals who cannot credibly claim a bona fide relationship with a person or entity in the United States. So what does this mean? This means that for all those individuals from those 6 countries who are seeking a visa to enter, if those individuals have family members or other similar relations to the to family members, or, for example, were going to be studying in the United States or had an employer in the United States, the travel ban is still blocked for those individuals. Similarly, for refugees who are in similar situations, the travel ban is still blocked as to those individuals. And so the stay was only lifted to some portions. I'm sorry, the injunction was only lifted as to some portions of the individuals affected by the travel ban, but the injunction against the travel ban remains in effect for numerous other people. So, so this is a mixed. It's disappointing in some senses, in that individuals can't. There's some individuals who are still going to be affected by this, but we're still very, very happy that many other individuals will not be affected by the travel ban at this point. And we're going to continue to advocate and litigate our cases before the Supreme Court going forward, to seek to have the travel ban enjoined in full going forward.
Great, thank you, Nico. So we now want to take some time to answer any questions about the different cases that received some feedback from the Supreme Court today. So let's open it up for questions. What I'm going to do is read through any questions that folks might have. So if you do have questions, please enter them on the dashboard in the webinar, and we'll be choosing questions that either the most people request or seem very pertinent. So if we lose ADAC v. Brewer, is it possible for current DACA recipients to lose their status?
That is a possibility, because one of the issues in the ADAC case that Arizona has raised is whether DACA itself is legal. So the Supreme Court might reach that question if it decides to take the case, and if there is a negative decision in that case.
Okay, if you have any information regarding the ACLU lawsuits to halt the deportation of Iraqis, could you share? I have a friend who's being held along with many other Iraqis. They have no travel documents and were picked up at a Homeland Security check-in.
Let me add something about ADAC first.
Okay.
This is Karen Tumlin at the National Immigration Law Center. I just want to add one thing about the important question about if cert is granted in the Arizona DREAM Act Coalition case, if there could be an impact down the road on DACA recipients. I think what's important is to just flag that, and Nico, of course, describes it before, there's a lot of ifs in that sentence, right? And that what we need to, what we need to focus on in this intervening period is what are the best strategies to ensure that we don't get down the road where DACA status is impacted in any way from this case. So first of all, and I think we just really need to be careful and not in walking the right balance of down the road, if those ifs come to pass and the case is granted and it's granted in a way that is expansive enough to include the one question about DACA, maybe down the road, if you lose, then that is a chance, but not, walking the balance of where's the program today? The program remains in place, and we need to continue to put all the pressure we can on this administration to do the right thing and stand behind the program.
So just to return to the question about the ACLU cases involving Iraqi nationals that's currently being litigated in Michigan, I don't have information, the most up-to-date information about what's happening in that case. We understand that it's fast-moving, that there was a TRO arguments recently, and I would probably best direct individuals to any ACLU materials on that, as they will know they'll be providing the most up-to-date information on that case.
So we have a lot of questions coming in around specifically the Muslim case and what some of the definition is of a bona fide relationship. So here's one iteration of the question. What exactly is defined as a bona fide relationship with someone in the U.S.? Specifically, I'm an asylum applicant. Can my parents travel to the U.S.? There's other questions about what that particularly means, just based on people's own situations. Like, how can it be interpreted?
Yeah, we're currently looking at the order, and we won't know for sure on exactly how it's going to be interpreted, in part because there were some general examples of the type of individuals who wouldn't, the travel ban wouldn't go into effect for. So, for example, it raised examples like that were in the litigation, both in our IRAP and Hawaii case. So, for example, if you have a family member, like if an individual wants to travel to the United States, if they have to see a family member or to reunite with a family member, that's clearly the type of individual who won't be blocked by the travel ban, because they are people just like who are in our cases, and those are the type of people specifically mentioned in the Supreme Court's recent order. It also pointed to individuals like students planning to attend, who had been admitted, who were planning to attend, or who had been admitted to colleges in a state. So, for example, that was one of the arguments that Hawaii had made in its cases as to how it would be affected. It also referenced, for example, individuals who had employment here in the United States. These are the kind of existing ties to individuals or organizations that the Supreme Court highlighted as the type of individuals who couldn't be blocked by the travel ban at this time. And so we don't know what that definitive list is going to be. We can only go by these kind of broad examples that were sketched out by the Supreme Court. And so we know that these individuals and similarly situated individuals won't be blocked at this time. We will be monitoring what happens with DHS policies, what happens at airports in the in the days and weeks going forward to make sure that the federal government is complying with the injunctions that remain valid, that were, in both our IRAP case and the Hawaii case, to make sure that to the extent that the Supreme Court has allowed those to continue, that they will be respected by federal officials.
Okay, so thank you, Nico, and to those of you who sent questions. We will have time at the end for more questions, so please keep sending in your questions and we will look through them and try to get through some of the questions that multiple people are asking. But before that, we are going to go on to our other agenda items. Next, we have a presentation on the health legislation and immigrants and public benefits by Matt Lopez.
Hello, everybody. I'm Matt Lopez, a health policy attorney here at NILC in our DC office. So I'm first going to talk a little bit about the Senate health bill that you've probably been seeing a lot in the news. I'm going to focus a little bit on why this is an issue that is important to immigrant families, immigrant households, and why folks on this call should be paying attention this week. So the bill that the Senate introduced last week, after a very secretive process of writing the bill, is much like the version that the House passed, you might recall, a couple months ago, the American Health Care Act, which took several different attempts by House leadership to get through, but eventually went through in some very drastic effects on the health of millions of Americans, including cutting likely health care from 23 million people in the next 10 years. This bill largely takes the template, that original bill, but in some ways makes it much worse. It still continues to gut the Medicaid program, which provides coverage for many low-income families and also really provides a bedrock for coverage of low-income folks, even those who aren't eligible. Medicaid is really what makes other affordability programs able to exist, and it's also largely what allows states and localities to think about how they can cover their own communities. So the success of the Medicaid program really is important to the success of coverage for all folks, including immigrants who may not be eligible for Medicaid, largely because of family members or because of the cost of the system in general. The bill also does some pretty bad things for affordability for folks in general. If this bill were to go through, it would mean higher premiums, more out-of-pocket costs, but yet probably lesser coverage. It essentially, I think one of the best examples I've heard of how to describe this is it is taken on the assumption that poor people should pay more for coverage that does less. And that's really what this plan does. It also allows states to opt out of certain insurance coverage benefits, and this is where the idea that people say, well, what about pre-existing conditions? It does not prevent, it says that insurance companies can't discriminate based on pre-existing conditions. Well, technically that might be true, but it does also allow states to say that they don't want to, they can just notify Department of Health and Human Services that in the plans offered on the marketplace, they just don't want to cover certain things. And they're not required to, actually for that they don't even have to, for many of these they don't even have to notify. They can just decide not to cover the kind of essential health benefits that are currently covered, like maternity care, like things like cancer coverage, things that might be expensive. It also includes cuts for Planned Parenthood, which for many immigrant women is one of the sources of health care that's available when other options aren't. It also goes further. This bill, unlike the House bill, makes access to the marketplaces unattainable for many immigrants. The House bill made made cuts to the tax credits. It said that the only people that could get subsidies under that bill were people who are qualified immigrants. So that may be the folks that you're familiar with who currently are Medicaid eligible. This was, the Senate says, well, only that smaller group of qualified immigrants, which the House bill included, should get the subsidies. But we're also going to make it so that that's the only people that even can buy on the marketplace. So what does that mean? Can I get the next slide, please? Who would lose access? Who would lose access to the marketplace and to the tax credits that make their health care affordable? Well, if only qualified immigrants are eligible, then the people who would be able to still get affordable health coverage are mainly green card holders and people with some humanitarian qualities, refugees, asylees, some VAWA petitioners. There are these kind of particular classes that are described in statute who are eligible as qualified immigrants. But if this law were to go through, many people that Obamacare considers lawfully present, which is the standard currently used, but are not qualified immigrants, would then be cut out of receiving tax credits and being eligible. Some areas right now, for instance, if somebody were in this case in the District of Columbia where I live, that would mean that because there's no individual marketplace outside of the Obamacare marketplace, that means that all of these people would be unable to even purchase insurance with their own money in a place like DC right now. These include some survivors of crimes. We're talking about youth visas for those who are familiar with it. That is oftentimes people who are somehow witnesses and survivors of trafficking situations, although T visa holders are qualified, U visa holders are not. There's also a group of people often referred to as COPA migrants. These are people who are allowed to enter the country because of the United States from the island nations that are listed, partly because of agreements with or out of agreements that the United States has made with those with their homeland, largely because of some ways in which the United States is responsible for situations that exist in their country. It would eliminate the access to subsidies for those folks. It also includes some torture survivors, and then as is mentioned, some people who are in the process of joining their family but have not yet received a green card. That's one of many types of be unable to access subsidies or coverage. Can I get the next slide? So what can you do? Things are moving fast. We're expecting it's possible a bill could happen this week, but that doesn't mean that there's no time. There are still time to make your voice heard. Make sure that the folks who represent you know why these issues might be important to you. Be active on social media. Sharing your story. The hashtag #ProtectOurCare is the main hashtag. There are also folks concerned with Medicaid, and I encourage folks to look at the one doesn't have to look hard to find people advocating against this health bill with organizations like Families Today and others. There are also generally local events in your area that you can connect to. Our friends at Indivisible have created a option at ouramendments.org, which allows individuals to create a possible amendment to the health bill that would say that this bill must require that individual person not lose their access to affordable coverage, which they can then advocate for their member of Congress to introduce, their senator to introduce on their behalf. Those are some things that you can do. I'm going to change course slightly because it's been a busy week in immigrant access to health and economic supports, and talk about one other issue. So if we could switch to the next slide. There were some comments that Trump made referring to benefits in Ohio, or in Iowa, excuse me, last week. So if I get the next slide, thank you. It's important to note that this is just talk for now. The second, bullet point that I have in bold is probably the most important thing I can say, which is that there's been no change in law. What Trump said the other day was Trump speaking, and folks should know and be prepared to explain to the people in their own communities that nothing has changed. So what he talked about was possibly, he said, introduce legislation that would further limit immigrants' access to, this is Matt, to income-based safety net programs for at least 5 years. Yeah, after they arrive in the country. They are largely issues that are already law. But it's important to note that they are in the spirit of the draft executive order that was leaked in January. It's a reminder to all of us who have worked on this that they must continue to prepare, push back on the anti-immigrant agenda furthered by this administration. So that's what I have on those issues.
Okay, great. Thank you, Matt. We're now going to move on to a DACA update by Ignacio Rodriguez.
Hi, everyone. Ignacio Rodriguez, Immigration Policy Advocate at NILC. I'll be moving through my slides rather quickly to reserve enough time for questions and answers at the end. But I just wanted to provide a quick update on what's going on with DACA. So if you recall the slide in front of you with the possible scenarios, we've gone over this on previous field calls as to what can actually happen with DACA under this administration. Since January, we have been in scenario number 2, where the DACA program continues, yet we have no idea if the administration plans to keep it. Then on June 15th, the Department of Homeland Security, DHS Secretary John Kelly, signed a memo rescinding the Obama administration's November 2014 memorandum, which thus officially terminates DAPA, expanded DACA, and the ability for DACA to be issued for 3-year periods rather than the current 2. DHS did clarify that if you have a valid 3-year work permit, you do not have to take any action. You can keep it. We'll know more about how the DAPA memo, we'll know more about how the DAPA memo rescission affects the Texas versus U.S. case in the next few weeks. We don't know if it'll end the case may change. We just don't know right now, but we encourage you to keep up to date, visit our website, and also sign up for our listserv if you haven't already to find out. Then there were questions around what does the DAPA memo rescission mean for DACA itself? Well, by the morning of June 16th, there were already rumors circulating that the memo and the accompanying materials signaled that DACA was safe indefinitely. However, these were only rumors. The memo and the related materials only state that the decision does not affect DACA and that people can continue to apply and renew their DACA. There was no affirmative promise by the administration to keep DACA indefinitely, which is why the advocacy to keep DACA continues. The White House also clarified that morning that DACA continues to be under review. So going back to my first slide, we continue to be in scenario number 2. DHS said in their statement when they rescinded the DAPA memo that they will allow work permits to be valid until expiration, which signals to some people that if DACA were to end, we would most likely be in scenario number 3. Scenario number 3, where DACA ends and DACA and work permits are valid until expiration, is also listed as a scenario in the leaked yet never signed memo. But the reality is we just don't know what's going to happen with DACA, and so we must continue to prepare for all possibilities. In the meantime, we continue to recommend for initial and renewal applicants to speak to an attorney or a BIA accredited representative before applying, and to ideally file a G28 notice of entry of appearance as attorney or accredited representative. Here we also list some considerations you should keep in mind before applying. But for the sake of time, I'll focus on the importance of considering whether the new enforcement non-priorities apply to you. Because if you look at this chart comparing the old priorities with the new priorities, things have definitely changed. So for example, someone with the prior deportation removal from before 2014 could have applied and received DACA in the past, but may now, upon renewing, be considered an enforcement priority. Same with someone who has certain charges. So again, it's best to speak to an attorney or a BIA accredited representative to get an individualized assessment as to how this applies to you. We have seen questionable practices by CBP and ICE, and here we list a couple of examples. To summarize, these are examples of people being apprehended, detained, and even deported. These also include examples of people who are being targeted for their activism and for speaking out. We don't know if this is all because of a change in policy or if it's because immigration agents now emboldened by the Trump administration are arbitrarily targeting immigrant communities, including those with DACA. But still, we must remain vigilant and report these injustices at once. And then we've also received questions around the treatment of DACA applications themselves. USCIS reported that there's been over 107,000 renewal approvals and over 17,000 initial approvals since January. It's important to keep in mind that this time period covers the time that Obama was still in office, January 1st through the 19th. So we really won't know until the next set that USCIS releases how the Trump administration is handling these applications. We have only seen a handful of cases experiencing DACA renewal delays, but if that's not what you're seeing, if you're seeing something different, or if you yourself are experiencing a delay in your application, we highly encourage you to contact us at reply@nilc.org. And then according to the data also provided by USCIS, processing centers are taking up to 4 to 5 months to process an application. But again, if you're seeing something different, we highly encourage you to let us know, because we would love to work with you to ensure that DACA remains available and accessible. Thank you.
Thank you. So just before we move on to our final presentation, I think I did want to reiterate both with the presentation that, Ignacia gave, along with, what we have moving forward in terms of the IDAPI Brewer case that's going to the Supreme Court. Is the next couple of months are going to be really critical in terms of our advocacy as a movement to highlight the importance of DACA, and so we do want that to remain on everybody's radar screen as we move forward. And of course, we will be providing more information in the days and weeks ahead. So I'm going to turn it over to Jackie Vimo to give a quick update on the congressional budget.
So I know everyone is really overwhelmed by everything that is going on, but meanwhile we are also in the process of working towards approving a fiscal year 18 budget. Here's the next slide, please. As some of you remember from the 2017 fight that we had a few weeks ago around the continuing resolution and the supplemental monies to keep the government funded, the agreement had been made that even though President Trump had asked for money to build a wall and $3 billion increase, he didn't get technically money to build the wall, but he did get $1.5 billion additional dollars in the 17 fight just a few weeks ago to increase the number of Border Patrol agents and to really kind of, even though they didn't actually get specific hiring numbers, it was money to really prepare for to funding this massive deportation machine. And so I think that as we're moving into the 18 budget, it's important to remember that even though many people are referring to the 17 fight as a victory because he didn't get his wall, quote unquote, there was actually money to lay the groundwork for that, and also $1.5 billion additional dollars is really a problem, especially given there have been recent reports also of fiscal mismanagement at DHS, abuses of power within ICE agents taking advantage of their positions of authority, and as it is, they're not even able to hire the Border Patrol agents that they even have funding for, because a lot of them cannot pass polygraph tests that are required. And so as it is now, they're trying to even reduce the standards for polygraph tests for certain Border Patrol hires so that they can meet their hiring targets. And so what we're seeing here is a situation in which we have an agency that already can't spend the money it has, that is riddled with corruption, and now we have President Trump on Tuesday, May 30th, released his fiscal year 2018 budget request, which included two major pieces. One, it included devastating cuts to means-tested benefits, as many of you have heard about, including cutting Medicaid by nearly half over the next 10 years, food stamps by nearly 30%. In particular, he broke his promise to not go after Social Security for folks with disabilities and so forth, and cut $72 billion from Social Security programs. Some of you may have seen some of the great protests that folks did, that disabled activists, disability activists have did in Congress, doing sit-ins in wheelchairs this week, and also cuts the EPA and hurts the environment by 1/3, ends all federal funding for Planned Parenthood, and eliminates programs to help kids afford to go to college. So all of these cuts are being done for two reasons. One, to pay for the tax cuts for the wealthy that are part of the Trump administration and Republican GOP tax plans, but also to fund this massive deportation machine. So he's come back with a $4.5 billion request. He wants 1,000 new ICE agents, 500 new Border Patrol agents. He wants to finally build that wall, and also includes increased collaboration between ICE and local law enforcement. So it's extremely important that we really get the word out that we will not allow them to make cuts to programs that are crucial for communities' health and well-being in order to pay for tax cuts for the wealthy and for this massive deportation machine. And really, I think that a lot of the effort, the focus had been on the wall, but really while that continues to be very important, I think that many people, including both those that are supportive of immigration issues, Democrats, Republicans, don't seem to understand that really one of the biggest threats, if we're talking about separating families and threats to immigrant communities, is pumping more money into ICE and CBP and into DHS to fund this deportation machine and tear families apart. So two more just quick things that were in his budget request, which is one would restrict the child tax credit and the earned income tax credit to filers where everyone on the return actually had a Social Security number. So as it is right now, the EITC already is restricted to those with Social Security numbers, but what this would do is to say is if you're married to someone, who have a dependent who doesn't have a Social Security number, if you have an ITIN filer who's a parent and you have their child who's a U.S. citizen, they would be denied access to these tax credits that are really one of the most important anti-poverty measures that we have right now, and it primarily would affect the 5 million children that are in mixed status families. While of course we're concerned that it affects everyone, it primarily targets U.S. citizen children in mixed status families, and this is just extremely concerning. And we're working on a sign-on letter, a congressional sign-on letter to oppose that. The bill also would include mandatory E-Verify in the president's budget request, and also ask for increased collaboration between ICE and local law enforcement. I will say that Senator Kamala Harris put together a sign-on letter opposing the ICE budget, the DHS and CBP budget, and 19 members of Congress signed on. Not only does she oppose, and do we oppose the $4.5 billion increase, we're actually asking for cuts to DHS and to ICE and CBP, because as it is, the agencies are out of control and are, violating the basic rights of folks that they interact with. And so we're really, that's going to be our message. We're going to be rolling out a campaign in the next week or so with the hashtag Fund Families Not Fear, where we're going to be putting out postcards for people to sign on that say they want their tax dollars, and this is anyone. Doesn't have to be U.S. citizens. It can be immigrants. That everyone pays taxes. That we want our tax dollars to pay for, fill in the blank, schools, libraries, healthcare, and it will say on that bottom of that check that is void if it goes to fund fear. That we do not want our tax dollars to go pay for this. So this is a fight that continues. I know there's so much going on. It's going to be really important during the summer recesses that we let folks know that we're outraged by this and that the immigrant communities are not going to be sold out again to pay for walls and fear and tax cuts for the wealthy. So that is that, and look forward to hearing more from you on that.
Okay, thank you. Thank you to all our presenters. We're now going to go through some of the questions that have been coming up frequently across the different topics that we've covered today. So one question particularly around the Muslim ban case is, being that it's likely that some refugees do not have family ties to the U.S., what is the rationale behind an ongoing injunction, and what is the likelihood that those types of refugees will be able to enter the United States?
The Supreme Court's order states that that it's not just individuals with pre-existing relationship to an individual, but it also states that if there's a pre-existing relationship to an entity. And so there is some uncertainty about what this latter part means with regards to refugees. Many refugees have been working with refugee resettlement organizations like our clients IRAP and HIAS, and those entities' pre-existing relationship very well seem like the type of pre-existing bona fide relationships that should make those individuals able to continue to move forward with their resettlement process and eventually secure a visa to enter the United States. There is some uncertainty about whether that is the case, and that's part of what we'll be doing in our due diligence to try to determine how DHS will implement policies to comply with the Supreme Court's order here. But we believe that by the terms of the Supreme Court's order, it's not just individuals with a pre-existing relationship to a family member or a specific individual, but it's also those who have bona fide relationships with entities here in the United States that also should be allowed to continue with their refugee resettlement process. However, as I stated, this is really a situation in flux, and we'll continue to advocate to make sure that as many affected individuals are not prevented from coming into the United States as possible. And so, to that extent, I just want to reiterate that that in addition to the ability to continue refugee resettlement for individuals who have existing relationships to individuals or entities, for those individuals, the cap of 50,000 individuals who can be admitted won't be a bar either. So both portions of the executive order that affect both the number and types of persons who can enter shouldn't stop the ability of individuals with the existing relationships between individuals or entities from being able to continue with their refugee resettlement process.
All right, thank you, Nico. So we're now going to move to a question around DACA application times. There's a number of kind of questions, comments, saying that folks have seen DACA applications being processed relatively quickly. So Ignacio is going to just kind of clarify on where things are at and what our understanding is of the processing situation.
Yeah, so we've also seen some cases processed in about a month or so, but it really varies. The data I shared regarding USCIS processing times of between 4 to 5 months, that's released by USCIS, and they don't differentiate between initial and renewal apps, so it could be more of a sign of how long it's taking for initial applications to be reviewed. Still, we've seen USCIS are actually meeting their goal of processing DACA renewal cases within 120 days. And it really, I mean, there's various factors that can determine how long a case takes to be processed, and one of them includes just how many cases are in the queue by the time your application is received. So we have seen a variation. Unfortunately, we haven't seen delays except for in a handful of DACA renewal cases. But if you've seen anything differently, we encourage you to let us know at reply@nilc.org.
Okay, we now have a couple of questions about immigrant access to health care under the Senate bill. There's been some requests for Matt to both clarify what the proposal is vis-a-vis immigrants and to go into a little bit more detail. So Matt, if you might be able to do that.
Sure. So basically what this does is under Obamacare, the standard for enrolling in Obamacare Marketplace and in receiving tax credits and other subsidies is the standard of lawfully present, which is just about anyone who has some sort of recognized status, or often many people who are applying for a status, except for people who have DACA, who are specifically excluded, but for this whole host of immigrants. What this bill would do is it would shrink this to be just people who are qualified immigrants. So it would mean just people who have a green card or one of a few different statuses that are mainly the kind of humanitarian statuses like refugee or asylee status. This would cut out all people who have non-immigrant visas, U visas, well, most non-immigrant visas, I should say. So like U visas, work visas, folks like that. You have people who have who are applying for asylum, people who are applying for a green card but do not have it yet. You have folks who, maybe received withholding of removal or deportation under the Convention Against Torture. So you have torture survivors. So you have this kind of whole list of people that aren't included in that narrow, very narrow list. All of those people would be excluded. And maybe it might be easiest we can send around with the kind of, as a follow-up to this, a list of that we have of what the term lawfully present means for the Affordable Care Act. Kind of spells out all of those statuses, and there are some that say this person is lawful, or this group is lawfully status because they are qualified immigrants. Those are the only groups who would remain eligible. All the other groups would be ineligible.
Thank you, Matt. We now have a question for Jackie on how realistic is Trump's budget request. Do you think that Congress will grant him everything he's asking for? Is Jackie available?
Can you hear me?
Yeah.
Yep. So I think it really depends on, how much we push people who, are resisting his agenda. So, a lot of people have claimed that this budget was quote unquote dead on arrival, when he released it a few weeks ago. But I think that's a very dangerous position for us to take. This isn't really going to be decided until the end of September, and there are going to be lots of other things that are going to be, well, the deadline is the end of September, but it could be decided at any time before then. But I think that it's really important that we take this as a very real threat, and that we understand that we've already seen a situation with the budget, with the 17 budget, where immigrants, were really sold out to kind of keep out some other bad provisions. So the message has to be that it's real because it's on the table and we keep on fighting.
Thank you, Jackie. So the last question is around the timeline for ADAC v. Brewer. We've had a couple of questions about whether it's going to go back to the Supreme Court and what the timeline is going to be for the process.
Great. So we are in the process right now of trying to figure out our kind of best estimate as for the timeline. Because as I mentioned, Supreme Court in our Arizona DREAM Act Coalition v. Brewer case, the Supreme Court asked for the federal government, that is the Solicitor General's view as to the issues in this case. And so we've been trying to figure out how long this will take. Normally, the Supreme Court doesn't issue a deadline by which that the Solicitor General can file. And some of the research that we're encountering suggests that it could be up to 4 months for the Solicitor General to file. That being said, the Solicitor General could file his opinion at any point between, after this order's filed, which really highlights the importance of ensuring that the federal government knows that it's got to stick by its pledge to stand behind DACA recipients. And so we just can't be sure of the precise timeline. But what likely won't happen is that the Supreme Court won't decide whether or not to take the case until it hears the view of the Solicitor General in this case. And so we'll be continuing to try to update this information to see if we can get any better numbers, but there isn't a hard deadline. And we'll continue to update folks on this call, as well as provide information through our website and other social media accounts to let folks know what the timeline is going to be. But as to right now, it could be in the range of months.
All right, thank you, Nico, and thank you to all of our presenters today. We will be sending everyone who attended this webinar a copy of the audio recording as well as the slides. You also see our email addresses here. If you have any questions, please feel free to email us. I also want to add that over the course of the next couple of weeks and couple of months, please check our social media accounts, our emails, because we are going to be providing regular updates as well as sense of timeline and different activities that folks can engage in to put pressure on, whether it's the administration or a campaign around the different kind of Supreme Court happenings that we're seeing. So please keep up to date, and thank you for attending this call.